back to Mississippi, where a motions hearing is underway for defendant Carly Gregg.
The then 14-year-old is accused of shooting her mother, Ashley Smiley, and her stepfather, Heath Smiley, and then inviting a friend over to see her mom's dead body.
Right now, the court is hearing arguments over the defense's motion to suppress Gregg's urine test. On the stand right now is a Rankin County youth prosecutor who's testifying as to that drug test done on the defendant, Carly Gregg. Let's get you back in.
Sit here today.
No, I don't have any information.
No further questions, Your Honor.
Stand down. State may call its next witness.
No further witness, just the argument, Your Honor.
Defense have any witnesses that wishes to call on this issue?
No, Your Honor.
All right, argument by the state.
From here is voting, Your Honor. The state outlined in our response and then filed an amended response. I want to bring that to the court's attention. Initially, we believed that the Juvenile Detention Center was under a particular grant through the OJJDP, which is the Office of Juvenile Justice and Delinquency Prevention. That federal grant does require drug testing. Upon communications with the Board of Supervisors, it's actually a different grant than we initially cited in our response. So I did file an amended response attaching the appropriate grant that does in fact require drug screens of all offenders at entry. Or that does require, drug screens, as well as the Rankin County Sheriff Department's Juvenile Detention Center Policies and Procedures 2.2F. Those were provided to me by the Sheriff's Department, which again outlined that each offender is screened there at the detention center immediately. It also outlines the policies and procedures that are to take place upon entry. These screens, as you heard from Mr. Gerber, are very reliable. The state is not attempting to use this screen for quantification, rather for presumption. As pointed out in our response, the defendant has admitted during particular evaluations and through other witnesses that she did in fact use marijuana. She has said that she used it during her assessment with Region 8 as well. She says that she smoked it. This happened on the 19th. She says that she smoked it on the 18th at least. We believe that this information is certainly pertinent since she has asserted her right to claim an insanity defense. As this court's well aware, in cases such as Crawford v. State, once the defendant puts their sanity at issue, the door is thrown wide open for the admission of evidence of every act of the accused's life relevant to the issue of insanity or sanity and is admissible in evidence. That's Crawford v. State, 867 Southern 2nd, 196. Additionally, Mississippi Rules of Evidence 703 states that an expert can rely on facts and data that are not necessarily admissible in evidence. And so our doctor, Dr. Pickett, has relied upon Carly's admissions of using marijuana as well as this presumptive test to show that is and does call into question her mental state. As this court is also aware, voluntary intoxication is not a defense to murder. It does not entitle you to an insanity defense. And so we believe that 703 as well as Crawford and the admissions by the defendant make this test even more reliable. This isn't just a piece of paper that shows that she had marijuana in her system. We have the defendant herself saying that she'd smoked marijuana at or around the time of the crime, as well as additional witnesses that we intend to introduce. As outlined in our arguments, we also believe that this urine screen is akin to the DNA buccal swab found in Maryland v. King. There was a 3-part test. We believe that it's similar in that the Rankin County Detention Center's booking policies require that all offenders be screened, that urine sample is the least and minimally invasive drug screen that's available to them at the time. And as such, we believe that the drug screen itself should be admissible under Maryland v. King. Also as cited in our arguments, and what Mr. Gerber talked about today was that these tests are done for the safety of both the offender as well as the facility. And we believe that that record is actually a part of Carly Gregg's medical records. And because of that, and because of her claim of insanity, she has waived all medical privilege with regards to anything that might have to do with her mental state at the time of the crime. Specifically, we cite to Rule 503F of the Mississippi Rules of Evidence, as well as the cases outlined in our response. We ask that the state be allowed, that our evaluating psychiatrists be allowed to review and talk about the results from this urine screen as they do affect the defendant's mental state at the time of the crime. And then additionally, we would argue that if a search warrant was required, Holloman v. State would apply. In this case, it was a drunk driver who killed someone driving in a car. Law enforcement was on the scene. They observed the presence of beer cans, empty syringes, and bottles containing unidentified liquids. At the time, the person's blood was drawn, and also a urine sample was taken. There was the presence of methamphetamines and cocaine. This sample was taken without a warrant, similar to what we have here, and the court found that a warrantless search is permissible in certain exigent circumstances if it can be shown that grounds existed to conduct the search that, had time permitted, would reasonably have satisfied a disinterested magistrate that a warrant should be properly issued. And similar to Holloman in this case, the substances that were in Ms. Gregg's system at the time can dissipate over a period of time. And this screen was done on the 20th. She was brought over hours later. And we would argue, Your Honor, that if a warrant was got, if we had received a warrant, had to serve it on her and get an additional sample, that would be even more far removed than this sample was on the 20th rather than the 19th at the time of the crime. We would, of course, also state that, as pointed out, it's going to come into evidence that Ms. Gregg was using marijuana. And
all right, let's bring in trial attorney Bruce Rosenberg, who's joining us this hour. Bruce, thank you so much for being with us on the program. Interesting and nuanced argument, a couple of layers here, but I think it's very base. At least what the defense is arguing is that because of the law in Mississippi, once she committed this crime that is punishable by life in prison, she is treated by the system as an adult. Now, that's the legal reality. In reality, she's a juvenile. So she went to juvenile court and was tested. They're trying to keep the results of that test out for good reason. It shows that she was on cannabis at the time, or marijuana. They're claiming a mental health defense. That would not be helpful for them. What do you think about these arguments?
I think both sides are presenting very good arguments. I think the prosecutor has laid out and stated the law very plainly and clearly that in that state, this is how things are done and why it should be admissible in this court. I think the more important question or point is that the defense counsel really raises a good point about chain of custody, about the veracity and reliability of the testing, whether or not it should be admissible. I think testing the validity of the results is a very important aspect of what's going on here, and I think both sides are doing an excellent job making their case in front of the court.
You know, I agree with you, but I have to say this, Bruce. What did we think when we hear, and she admitted to using marijuana? Granted, she's only 14. A 14-year-old's probably going to spill it and say everything. But when you have that admission on top of it, is it as important that those results come in?
Actually, I'm not so sure it is. I think the admission is much more important than the actual test results. I think the fact is that they can put the testimony of the defendant, the statement in front of the jury, and I think that's the most impactful evidence. I think the questionability of this test result really is maybe letting the tail wag the dog. I really don't know that it's that important here to get this evidence admitted at this point.
Bruce, talk about why it's so important for the defense to try to keep this out in light of the fact that they have a mental health or a not guilty by reason of insanity defense.
Well, I think that for their defense, keeping out any evidence at all is part of the challenge. Every piece of the puzzle that can be knocked out is something that works to the advantage and raising the standard of meeting reasonable doubt. If the defense counsel can put reasonable doubt into the jury's mind by use of this test or the testing methodology or results, then that is something that maybe won't overcome all the pieces of the puzzle, but is an important part and should be argued by the defense.
I just wanted to point out, Michael, she has her own attorney as well. Like, I know there's defense counsel, but there was another woman seated by her that I believe also is involved because although charged as an adult, she's 14.
Yes.
I don't know if that makes sense.
Yes, she does. She has to protect certain rights that are not related to adult court.
Exactly.
And she's representing her in that sense, right?
Yes.
Yeah, no doubt about it. All right, stand by, Bruce. We're going to take a break. When we come back, I think we're going to hear the defense's side of this argument, why these tests should not be allowed in. You'll be here on Court TV, your front row seat to justice.